Hello everyone, I'm Robert Allen, your MTSA Mooting Officer. Today I'm joined by James Pickering QC. James was called to the bar at Middle Temple in 1991 and has developed his practice in commercial work. He has performed and witnessed advocacy from both sides of the court, becoming a Deputy High Court Judge in 2018. Last year he was elected Head of Enterprise Chambers, and a week before the UK's first national lockdown, he took silk. It's certainly been a busy couple of years for you, James.
It has, yes.
Has judging in these last couple of years altered your perspective on what makes for good advocacy?
Very much. I think I was a fairly decent advocate before I became a judge, but after I became a judge, receiving skeleton arguments, listening to oral submissions, it made me realise what did work and what didn't work. And at the Chancery Bar, I'm glad to say that the quality of advocacy is pretty high. And very occasionally you get bad submissions or bad presentational style. And it certainly set off warning bells with me thinking, right, note to self not to do that. But more often, when there was something which was particularly effective, when a barrister, he or she had a particular way of presenting a point or particular structure in their argument, often it sort of went, again, it went home in a good way. Okay, that's something to note, to try and adopt myself. So the short answer is yes. I think it has improved my own personal advocacy.
Can you give a slightly more specific example of that? Obviously, it's very much case dependent, but of something really good that you've seen, a trait in another advocate that you've actually taken on board and thought, right, I'm going to see if I can bring that into some of my own arguments.
Well, something which I think is probably something which every advocate should try to do, whether they're very junior or very senior, it's having confidence in what you say, or appearance of confidence. Obviously, you can't, it goes without saying, you never mislead the court. You should believe in your case. But you sometimes see an advocate and he or she will say something about a position of law or a position of fact, and will say it with such supreme confidence that the judge thinks, gosh, this must be right. Whereas sometimes you see you hear a barrister and he or she may say something and in fact you know it's right, but they sound very unsure about the position, and you start to question it. And obviously ultimately a judge has to make sure, just because someone sounds good doesn't mean you accept it. That goes without saying. You have to challenge everything, but in terms of an advocacy presentational style, it certainly helps when the advocate comes across as in a very straightforward way, but just believing what they're saying, that it's a credible point, as opposed to someone who comes across looking rather doubtful about their own points, almost being too apologetic. So obviously you show deference to the court, but don't be too apologetic. Say your point straightforwardly in a strong, clear way.
This is something that we've discussed in previous conversations in this series, is when you're a student, it's very difficult at times to have that confidence because you're still learning how to show that deference to the court. You're still, in some cases, you're learning the law as you're going through delivering these submissions. You know, the research period, it might be the first time that you've covered that area of the law. So it's particularly difficult to show that confidence at times. How do you go about trying to cover confidence if it's not something that you have? How do you go about trying to give the appearance of confidence?
Get on top of your brief, get on top of your law. It's as simple as that. And we all have to do something for the first time. If it's an area of law you're absolutely familiar with, you naturally have that confidence. If I know, for example, I do a lot of commercial work, insolvency work, and so I feel confident when I'm dealing with that. But over the years, I've had to deal with other matters which are tangential to what I'm doing. For example, there may be sort of planning issues or tax issues or something which is on the side, or accounting issues, and the answer is get on top of it, and make it clear that you're on top of it. And yes, of course, you'll never totally be as familiar with that area as with your own area. That's fine, but just get on top of the area as best you can and come across as if you know what you're talking about. Hopefully you do know what you're talking about.
Sometimes more than others, perhaps. How do you think your own style? How do you think your own style has evolved over the course of your career? Because you've been at the bar, dare I say it, for almost 30 years now. So how's that style?
Absolutely, yes. Well, hopefully, in terms of the confidence point, that sort of comes more naturally when you're older, or more senior, I should say, at the bar. But that, so I feel like I've had to work less on that, because it's when I was younger, I wanted to come across as confident, and I had to work on it more. So that point has evolved naturally. But I think also, in terms of taking points and which points to take and not to take, this is something which you learn right from the start, and everyone knows the rules from the start. So I'm not saying anything new or groundbreaking, but if, for example, you've got 7 or 8 points, do you take them all or not? And sometimes you've got a client who's desperate for you to take every point. Well, obviously you take a view, and sometimes advancing a case which doesn't quite make it, that's probably fine. But advancing a case which is hopeless, you take up time, you lose credibility, and it may distract, you may lose focus, the judge may lose focus from the real argument. So you've got to always have a judgment view as to which points to take, and also in which order to present your points. The general rule is go with your strongest points first, or do you finish with your strongest point? I think it's generally good to get your main point over first.
Yes.
And as I say, that's nothing groundbreaking, but I think I've developed a better judgment over the years as to when to take a point or not, and if I do take various points, how to structure them, in which order. It goes without saying, it's vital to structure your submissions. You don't simply have a stream of consciousness. You need to have structures. And if you've got written submissions, skeleton arguments, no doubt there'll be lots of subheadings. And if you're making oral submissions, you can't have subheadings, but you ought to have the oral equivalent. So you might often start by saying, I'm going to be dealing with my submissions in 4 parts, 1, 2, 3, 4. And when you deal with part 1, this can be broken down into 3 parts. Again, this is nothing groundbreaking, but it's good to road mark your submissions so they're clear and structured. And so the judge, when he or she's taking a note, can make clear notes, or they can annotate the skeleton argument as the case may be. So I think, as I say, that's something which has always been the case. But I think over the years, I've developed better judgment as to knowing how to structure my arguments, which points to take and not to take, which points to drop, and which points I should emphasize and put further forward, or hold back to the end.
Yes. And from the judging point of view, how do you like to see advocates using their skeleton argument? Do you like to see a close following of that structure, or is it okay sometimes to go off that structure? As you say, if you adjust the way that you'd like to present your submissions, perhaps nearer to the time that you appear in court, can you be quite flexible with how you use that skeleton?
I think so. I think the idea of a skeleton is to get the points over pretty quickly. It is generally the first document the judge will read, and the judge will want to find out what the issues are. I mean, for example, if it's, let's say it's not a trial, but it's an interim application, what actually is the application? What are the issues? Yes. It's pretty frustrating to read that there's an application to do with whatever it is, whether there should be a preliminary issue or an injunction or whatever, and find out that all the points which could be an issue, you find out in the final paragraph, in fact, 3 of them have gone. There's only 1 live point. Yeah. You need to know right at the start what the issue is. So I think a good skeleton argument is very clear from the first couple of lines or paragraphs what the actual issues are. Mm-hmm. Also, it should be written on the assumption that the judge may be new to the case, maybe his or her second or third or fourth hearing of the case will be the first time, and they probably won't have read the papers beforehand. They'll read more papers afterwards, so it'll be their introduction to the case. So it shouldn't necessarily have it shouldn't assume background knowledge. So in short, I think the written submission should go in pretty quickly with what the key issues are, and making it pretty clear what the judge has to decide. In terms of following that up with oral advocacy, that depends on the case. I think there's nothing wrong with departing from it at all. Often it makes sense to use the same structure. Say I've dealt with 5 points here and I expanded on them in this way. But often there's no harm in dealing with advocacy in a different way. That'll depend on the situation.
Yes. And then for yourself as appearing in front of a judge, how would you prepare for that appearance? In terms of using your skeleton, would you prepare extra notes? Would you try and learn parts of your submissions? There's been all sorts of answers to this question.
Well, what I certainly don't do is simply have my skeleton and say I'm going to and just use that as my as my script. There's no point. For a start, it's a skeleton argument. It's not written submissions. Written submissions are slightly different. Sometimes at the end of the case, you'll be asked to give written submissions, and there'll be no chance to make oral submissions. So there'll be no chance to make oral submissions. A skeleton is a skeleton. Having said that, as we discussed, it's the first thing the judge will read. And so you want to make sure your points get across. So it's a pretty important document in that sense. In terms of preparing it, I therefore prepare it with that in mind. In terms of my oral submissions, I will generally have that broad structure in mind, but I might make a few overarching points at the start, some more general points, then go into the specific points and they expand. And if you're simply reading out your skeleton, there's not much point in having your oral submissions. It's always good to hold something back in your written submissions for you to develop in oral advocacy. So it's always a balancing exercise. If there's a key point, should you get in your written document because the judge has that point early, or do you hold it back so it has more impact and you can actually say something of value during the submissions? Again, that'll vary from case to case.
Yes, yes. So you're maintaining the interest of the court as well, because there must be nothing more boring than just having somebody learning their submissions directly from their skeleton argument and not developing on that at all.
It's always useful, absolutely. It's always useful that the same broad roadmap is followed. So you make a few overarching points, and now in my point one, my skeleton says this, I'm going to expand upon this, but again, you can see the subheadings and how you're following the arguments.
Yes, yes.
But absolutely, it's always good practice, and it makes sense for many reasons to have oral submissions which go beyond and expand upon the written submissions.
Do you ever feel nervous when you appear in court?
Yes, I think that's a good thing. The day you don't feel nervous is the day that you're underprepared.
Yes.
It depends on what the matter is, and in some cases you get more nervous than others. I've got a 10-week trial starting in January. A lot of parties, a lot of money at stake, and we had a Zoom PTR at the end of last week, and there were some 60 participants. So a lot of people watching, a lot of pressure, and so it's all the more important that you perform. But even if it's just one other person in court or no one's watching, you've always got a responsibility to your client. There'll always be a judge there, and it's always pressure. The good thing about our job is that we're doing something which makes a difference.
Yes,
it's an important job. The quid pro quo is that there's responsibility, and that brings pressure. So yes, I do feel slightly nervous at times, but that's not a bad thing.
So you just learn to embrace that, because it's difficult when you're first called upon to speak. It's getting over those initial nerves sometimes, which is the hard bit. Once you're into it and into the flow, you're all right, but it's starting off is often the hardest part. So is there any advice you have, perhaps particularly for students who've never done mooting and they're a bit nervous about how they'll feel on that first occasion, how to get them started in those submissions?
Yeah, that's actually a very good point. I was going to come on to that. I don't usually learn my lines, I often have sort of notes, but if you are going to have something which you know, be very confident for your start, be very confident. As you've absolutely said, Robert, as soon as, once you're up on your feet, I'm not saying things will always go smoothly, but once you're up on your feet, it's like being taking off in an airport. Once you're sort of in the air, yeah, there can be turbulence, but the worst part is just starting, and once you're up, it's okay. And so be confident with what you're going to say at the start. When you're making the claim or the application, that's usually more straightforward. If you're responding to a defendant or whatever, whatever you prepare in advance, what you want to say may have to be adapted depending on what's come beforehand. And of course, even if you are the claimant bringing the claim, you may have an opening line or opening session, and the judge may say, right, I don't want to hear this, and you have to adapt to the judge's agenda. Seem to prepare for those things. But in general, prepare for what you want to say, and in terms of your preparation, make sure you're particularly confident with your opening lines, even if it's something which is pretty just housekeeping.
Yeah.
I appear on behalf of X, my learning friend appears on behalf of Y. The matter before you today, as you'll have seen from the papers, is an application for XYZ. I propose to deal with my submissions in 5 parts. Just sort of get that part sort of smooth and nice, and hopefully the rest will fall into place.
Yes, it's not the hard stuff, it's not the law which makes that nerve-wracking. It's perhaps just the feeling for a student that they're representing themselves for the first time in a moot. Certainly when they become barristers, that they've got the weight of their client on their shoulders, and you just want to give the good impression to the court at the very start. And it doesn't need to be anything complex, but if you get off on the right track, your confidence is boosted and you can get into those complex submissions. But if you get off on the wrong track, all of a sudden you feel terrible, and it must be very difficult to then move forward and make much progress.
That's right. And in fact, often at the start of a hearing, there will naturally be some housekeeping in the event. Often once you've made your introductions, you can ask the judge, in terms of papers, can I make sure that you have skeleton arguments, X, Y, Z, you have authorities bundles, there have been some further documents being sent through, can I make sure the court has those documents? So these are fairly mundane housekeeping matters, which just gets you into the advocacy. They have to be done in the event, and so it's a nice way to get started.
And then when we are into that advocacy and making those key submissions, the judge, you can tell, human to human, isn't taking this on board very well. What do you do to try and regain the attention or the interest of the judge, even if you know that they're not going to be interested in what you've got to say on any of these points? How do you keep going at those times when things are going quite badly, to be quite honest?
Well, again, there's a lot of judgment call in advocacy. One thing I had to come on to in a moment is the ability to adapt and the ability to respond. And when you face an uphill battle from a judge and you get the impression that he or she is not with you, you have to make a call. Is it absolutely hopeless? If that's the case, then it's better to fall on your sword and move on to a better point rather than get up the judge's nose and distract the court from what your strong points are. However, sometimes you feel this is really going against me. The judge isn't with me, but you still need to have a go. Yes. And there are a number of reasons for that. For a start, you'll have a client behind you, either in reality or virtually, and the client wants his or her case argued in court. And so ultimately you've got to think of their best interest. And if the best interest is actually dropping it, you drop it. But if you still think there's a chance, and I've seen it on a few occasions, I've had it in my favor a few times and against me sadly a few times, where you think this point is definitely a dead duck and it's been turned around. Either I've turned it around or my opponent has, just by persevering. So you have, but the first thing is, do you do it? And it's a question of, is there any prospect? And what you have to do often is just step back. You have to step back with the court and maybe start again and say, Judge, I'd ask you to look at this from a different way. If I can start from a different perspective.
Yes.
So almost deconstruct and start again.
Yes.
So rather than just going over the same point, you are going over the same point, but you're doing it, giving the appearance that it's from a different direction.
I suppose that's one of the abilities of the barrister, is to word the same point in 6 or 7 different ways to suit whatever you think will best capture the attention of the judge.
Absolutely, yeah. One of the key points I mentioned earlier was in terms of adapting.
Yes.
I think that is very much a key skill of any barrister. However much you prepare, and you should prepare a lot, things will change and you will have to adapt. If you're making opening or closing submissions, you may have a structure, and the judge, he or she may, and it could work both ways, may hurry you on and say, I'm with you on that point. Or will give the impression that the judge he or she's with you, in which case you can probably take the point a bit more quickly. For example, if you were taking a judge through lots of authorities which go to the same point, and you get the impression the judge is with you, you move on. Conversely, if you feel the judge isn't getting the point, maybe you slow down. And maybe there were some authorities which you thought I don't need to refer to, and you do need to refer to.
Yes.
And of course, judges will, some will sit there saying not very much. Others will ask you questions. You have to be prepared for that. You can't say, sorry, judge, that's not in my script. You've got to answer the question. Now that's in submissions.
Yeah.
But adaptation mostly comes or is most acute in cross-examination. In cross-examination,
Yes.
you'll have your broad list of questions, and the way I prepare cross-examination, I don't write everything out like a full script, like a theatre script, but I have bullet points, and often I'll find that I'll be following my bullet points, and they'll go off on a tangent, and then then I come back, and you go off. A key is to listen to the answer. It's not a theatre script where you just read your part. You've got to listen to the answer, because that answer, at the very least, it may affect your next question.
Yeah, yeah.
And it's not, and you can't just go. I've seen some people do sort of flow charts, or if he says this, if she says that, and that's fine. But often it's more nuanced than that, and you have to be able to adapt depending on what the person says. And it may be not just a yes or no; it may be far more subtle than that. And you have to listen as well, because it may affect a question that you've got in 20 minutes time, or 2 pages in your notes time, or something like that. So it's important that when you actually listen to the question, listen to the answer, and that you adapt your next questions and subsequent questions accordingly. So that the ability to listen to the witness, and in terms of speeches, listen to the comments of the judge and adapt what you're saying to the circumstances is a key skill, which every barrister wants to have, and hopefully with experience you improve. But it's something to target right at the start.
Yeah, it's interesting. This is something which has come up several times through the course of this series. Is we haven't done cross-examination yet on all the different the various providers haven't got to cross-examination, so we will cross that bridge when we come to it. But it's interesting to hear how that relates to judges asking questions in submission advocacy, because there's often a temptation to park the issue that the judge has just asked and say, well, I'm going to come to that in 5-10 minutes time, so if your lordship will just be patient. And that really does not go down well at all. It's the preparation is to be.
It depends. It depends.
Yeah. Yeah.
It depends. Sometimes, if you could say, I'm going to come onto that later, and because it's going to come, it fits in more logically later down in my submissions,
yes,
that's absolutely fine, and the judge may accept that. If, however, it needs to be dealt with there and then, it's better to do it there and then. Sometimes, and a good tactic to have, or good thing to have at your sleeve, is you'll often see at any stage in court proceedings, a barrister will want to take instructions. If you're actually in court, you'll physically turn around and whisper with your solicitor. These days we use WhatsApp or other types of social media, and it can be done without stopping the proceedings. Sometimes you actually ask, can I have 5 or 10 minutes? There's nothing wrong with that. If you really are stuck on a point, you can legitimately say, my lord, my lady, it's that's a point which I can't deal with right now. Can I take instructions either now or at a convenient moment?
Yes.
And you can park it. If you can do it there and then, fine. But that is the best thing to do. But there's nothing wrong with taking instructions if you think that's going to be the best advantage of your client, and indeed to assist the court.
Yes, yes. Are there any, we've talked about positive traits of advocates. Are there any traits or habits that you've seen in court, either as a barrister or as a judge, that you have disliked from fellow advocates? Things that have weakened their arguments?
It's a skill to know when to shut up. We are paid to speak, but we're also paid not to speak. I have seen one of my opponents once grabbed defeat from the jaws of victory, and I thought I was going down on a case, and my opponent, she didn't need to say anything, but she got up to reply, and I thought, well, she doesn't need to say anything, and she got up and actually dug a hole. So don't feel obliged to say something. I remember when I was a student, I'd often watch in cross-examination barristers thinking, gosh, they're almost there. Just push home the next, ask one more question. It's like a boxer, like AJ having someone on the rings, and just want one more punch. And the barrister would not ask the next question. And I thought, gosh, you really have this person on the ropes. As I became more experienced, I realized there's a reason for that. Often you are there, you're virtually there. And if you ask another question, it can only undo the good work which has been done.
Yes,
the witness may have given something away, and he or she's clocked onto that. And if you ask them one more question, it gives them a chance to come back and recover. And you never know, if you had asked that extra question, it might have been a knockout blow, but it might have given them a chance to get up from the floor. So whether it's in cross-examination or whether it's in speeches, don't feel you have to say something, and sometimes just let the point hang if you think you're virtually there. Now, again, it's a judgment call. There's nothing worse than not saying something and finding the judge hasn't quite got the point. But so I think, to answer your question about unattractive traits or not so good traits, it's people who go on a bit too long and ask one question too many, or in the submission just go on again and be repetitive.
Yes, yeah. And in your student days, when you were watching those cross-examinations, were you a confident advocate back then? Would you say it's something that you have obviously developed and become better at over the course of your career? But is it something that you had a natural aptitude for, or is it something that you've had to learn and practice?
I think I had a bit of a natural aptitude, but undoubtedly I've improved. We were talking about confidence and the fact you have nerves. That's entirely natural. I remember when I was in the year before I went to bar school, I had a part-time job as a paralegal, and I was one of those annoying people sitting behind counsel, and I was pulling on the gown because I always wanted to stand up and speak and everything. So I always wanted to be the person not just passing up notes, but actually saying something. Yeah. And I think anyone who wants to be a barrister probably has a bit of that in them. We all want to be the person who's in the spotlight, and if you win, it's great, and if you lose, you have to take it on the chin. And the reality is that all barristers will win and lose cases. You hope to win more than you lose, but I think a better test is you want to win the ones you want to win, and some no one could have won. Maybe you've advised your client that there's no chance, but you have to do it anyway. And there are some cases which are grey cases and you make a difference and you don't win. You have to accept that. Everyone loses. There isn't a single barrister who's been in practice for any period of time who hasn't lost cases. You just want to make sure that the ones which you lose are the ones which you probably ought to have lost, and the ones which you win, you should win, you do win. Yeah. But in terms of confidence, I was reasonably confident, but I definitely improved. So in terms of students starting out, nothing wrong with being nervous. And it's what you want to do, hopefully, and you want to be there, whether it's just one judge and one person in court or lots of people there. And realistically, you're not going to be put into a 10-week trial with 60 people watching on day one or day two even, and so that's fine. And you will build and you will grow.
Well, it's that old thing, isn't it? If you're nervous, it means something to you. It matters. What you're doing is valuable and important, and we touched upon that earlier. You should embrace those nerves because you're doing something really valuable with your time.
Exactly.
Yeah. So just coming back and starting to think about concluding, what advice would you have for students who are watching this? Perhaps they haven't done a moot yet, as we say, they're going into the new year and they've got a few coming up, the Rosamond Smith, for example, or others. What can they be doing now, starting to think about in their preparation? And what can they really have as their focus when they first appear in front of judges and they're doing this?
Well, first of all, do moots. Moots are good experience. Secondly, if for those people who are actually in pupillage, so slightly a bit later stage, I suspect, never, or don't say no to a case. Take any case, any experience you have, even if your clerks say go up to a county court or a magistrate court miles and miles away, and it's not financially worth it, do it. It's all great experience, and you'll learn so much. And I learned a lot at bar school. I learned a lot more in my first 6 months of pupillage. In my second 6 months of pupillage, when I started going to court, I learned exponentially much more. And then your first few days of actually being a tenant, being let loose, you learn so much more. It's all about experience, and it builds up. So my first tip is do anything you can. There are various pro bono advocacy schemes as well, and moots are good practice. More generally, prepare, be on top of your brief, structure your submissions, both written and orally. Just have a structure, and signpost it to the judge. I'm going to say make 5 points. Yeah. Point 3 has got 3 subpoints, and have a structure. It's clear in your head. And when you make your submissions, try and keep to that structure. And the other big point is be prepared to adapt. Don't learn lines in that sense. You can learn a structure, you can learn an argument, you can practice how you want to say something, but listen to the judge, listen to the witnesses, and be prepared to adapt.
Yeah, excellent. I think that's all been extremely helpful. We've come towards the end of our time, but thank you so much, James, for giving us your thoughts on advocacy. And once again, I think I've certainly learned an awful lot from our guests today, and I hope viewers of the channel also feel that they do. It's really valuable to hear these insights from those who've been there and done it. So thank you so much for sitting down with me.
Robert, it's been a pleasure.